and welcome to the Downtown Charter Series. It's great to see some new faces here. Really great to see you out after a long weekend. So today we are very fortunate to have with us Professor James Muir, who is a joint appointment with the Faculty of Law and the Department of History and Classics. And so he's particularly well suited to be talking to us today about these three relatively unknown sections of our Charter of Rights and Freedoms. So just to give you a little bit of background on James, before I do actually, I should just say that if any of you need to use the washroom, there's a code on that door that you have to use. So please do note the code before you slip out. And you'll note that we have evaluation forms in front of you. Our funders require that we give them back feedback on our speakers. So if you wouldn't mind filling those out, we would very much appreciate it. And any comments you have about Downtown Charter talks you'd like to see in the future, we would also like to know about. And so, without further ado, I will introduce our speakers. So James, as I was saying, is a joint appointment and a historian. We're very fortunate in the Faculty of Law to have a historian with us. And James, interestingly, teaches a course in constitutional law that involves a game where the students have to actually construct their own constitution twice. So very, very unusual and interesting for the students to have constitutional law taught in this very novel way. So James joined the Faculty of Law in 2006. His research interest is in Canadian legal history, and his most recent book is a study of civil law in practice in 18th century Halifax. The name of it is Law, Debt, and Merchant Power, the Civil Courts of 18th Century Halifax. Really little known facts of history. James has published a number of articles, book chapters, and notably he has organized and spoken at a whole raft, a number of conferences. And so we are very, very fortunate to have him in our faculty. So without further ado, here he is to talk to you about protecting democracy, those three little known sections of our Constitution.
Thank you, Pat. This is Tyler. How's that? All right. Okay. So, as Pat said, as the subtitle of the talk says, I'm here to talk about the three parts of the Charter of Rights and Freedoms that almost nobody ever talks about, the boring parts, if you will. It's odd that nobody talks about them. They are among the very small number of rights in the Charter that are not included in the notwithstanding clause. These are rights that can't be abrogated by statute in any way. And yet, nonetheless, they're not often spoken about. If we think of what a constitution is a guide to the functioning of a state. It lays out the minimums of how government is to work. And if we think of the bulk of our Constitution as it still exists, which is the British North America Act of 1867, that act, all 170-odd clauses, deals essentially with how the federal and provincial governments should do their jobs and how they will function. And the democratic rights in the Charter will deal directly with those parts of the Constitution. In fact, unlike almost any other rights in the Charter or in the sort of new rights that were written into the Constitution in 1982, the democratic rights intersect directly with the rest of the DNA. The only other sections that really do in any clear way are the Aboriginal rights sections. So when we talk about democratic rights, it's worth asking or figuring out what we mean. So, what do we mean when we talk about democratic rights? Yeah, I'm asking you. Well, not just you, I can ask everybody in the room. But, yes. Anyway, what is a democratic right?
Right to participate.
The right to participate. What else might it be? The right to vote.
Quality of the vote.
The quality of the vote. provisions of the Charter bleed into how we interpret the three democratic rights.
Right to challenge.
The right to challenge. And we'll find that that is not a protected right. Yeah,
Definition of people?
the definition of people, to a degree, yes. All of those are part of what the democratic rights are, and the democratic rights, much like their other rights in the Charter, come as a result of long struggles. And yet, unlike the other rights in the Charter, the democratic rights garnered almost no discussion in 1981 and 1982 as the Charter of Rights was composed and as it was made into law and then in Britain and then enshrined here. In fact, they seemed as sort of almost secondary. But what I'll talk about as I'm walking through the rights is both how they were contested in the past and how they've been contested up to the present to a degree, and the way in which they might be contested or might be the focus of a contest of power in the future. So we start, though, we should try to figure out what they are. There are three sections. And in the three sections, there are essentially 5 democratic rights. And I'll talk about each of them, but I think we'll talk about them in 2 parts. The first pair, in section 3, are individual rights. And then the last group are in section 4 and 5 are fundamentally different rights from every other right in the Charter. They're not rights that individuals hold. So what is section 3? Every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. So, 2 rights. The right to vote, the right to run for office. Over the last several years, since roughly 2016, beginning in 2015, and it will continue for a couple more, and then there'll be a 20-year hiatus. Canadians have been celebrating the centenary of women's suffrage in Canada. In most provinces, and federally, women achieved the right to vote over the course of or just after the First World War. And it was a hard-won right. The campaign for suffrage began in the 1800s, just after women in Canada lost the right to vote. At which point, you're probably saying, what do you mean lost the right to vote? We don't necessarily think of women having the right to vote in the past. And so, they did, in some places, at some times, but to explain that, I think it's really useful to understand what it means in our constitutional context to vote. And to understand that, it's worth thinking about the United States. Why is it worth thinking about the United States? Because when most of us vote, we think we're voting in the way that voting occurs in the U.S. And we're not. The U.S. Constitution opens with the line, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." At its very starting point, we the people, sovereignty in the United States rests with the population. And how do they get to exercise their sovereignty? By voting. The people create their governments, and elections are core to that. Now, at the time of the Revolution, most people in the United States couldn't vote. Women couldn't vote, slaves couldn't vote. There were property qualifications in a lot of states, although not all of them. And so there was a limited franchise and a limited expectation of what people meant. But it was still this basis that government comes from the people, and so elections are a way in which the people their government. This is Canada's first line. Whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law, there's one thing that draws together the supremacy of God and the rule of law. One thing that is created by God and who has as its mandate the preservation of the rule of law. What's that?
Monarchy.
The monarchy. The Queen. Canada is at its very first line not a democracy, but a monarchy. For a lot of Canadian democracy doesn't rely on the vote at all. It relies on balancing the power between the monarch, the legislature, and the courts. There isn't anything essentially democratic in the legislature. If you think of the federal legislature, it's divided into two parts. The Senate is an appointed body. The Prime Minister and the Cabinet, the executive who run the government, who determine what the legislation will be, for the most part, that comes before the houses of assembly, either federally or the premiers in the cabinet provincially, are appointed by the Governor General. There is no requirement that the Prime Minister or the Premier or any cabinet ministers be members of an elected assembly or even of the Senate. Now, it's rare that we have prime ministers or premiers or cabinet ministers who aren't sitting in an elected assembly, or at least in the Senate. But it can happen. So we have a starting system that is not based on a structure of democracy, of people choosing, but a system that is constructed around the monarch ensuring the rule of law and the supremacy of God, and the monarch's authority being balanced by the legislature that may or may not have democratically elected people in it and democratically elected people running it. If we think of early parliaments, so here's a picture of the Parliament of Henry VIII, the electors and the members of Parliament were people of property. And they voted not because they were the source of government, but because they needed representatives of property to speak to the monarch on their classes' behalf. The Parliament is designed not as a democratic institution, but as an institution to protect particular classes of interests. In Lower Canada, so what is now Quebec, before Confederation, widows and some other women with property and no men in their families could vote, because the franchise in Lower Canada in the 1800s was a continuation of this basic idea, that voters, that the people who should vote, the people who should choose the assemblymen, are people of property who need to protect their property interests. And it's only in the 1860s, just as Confederation is moving its way through the various colonies and through the British Parliament, that the rights of these women to vote are removed in Quebec. And almost immediately thereafter, the suffrage movement in Canada begins. It's a long fight. It lasts until 1940 in Quebec, but it sort of gets its first major victory on the 28th of January 1916, when women achieved the vote in Manitoba. Federally, that right is achieved in 1917, and by all provinces have the right to vote by the end of the 19-teens, for the most part, although there are some weird restrictions on which women can vote until the 1920s. The right for women to vote, though, wasn't the only restriction on the franchise. Japanese Canadians could not vote. Throughout the first half of the 20th century, Chinese and South Asian Canadians could not vote federally or provincially in British Columbia, and Chinese people could not vote federally or provincially in Saskatchewan. Indigenous people slowly received the vote after the war, culminating in 1960 when status Indians were given the right to get themselves included in the federal franchise. And so in some ways, 1963 was reputed as being the first election where there were no restrictions on the right to vote. And the charter right was, it seems, seen at first as just a constitutional affirmation of those rights that had been achieved by 1960. It wasn't clear to the charter writers that they thought that they were granting new rights. In fact, they didn't think they were. But the problem was that in 1982, a lot of Canadians were still excluded from voting. The first group were non-citizens. Their exclusion remains right there in the language of the clause. It's the only clause that identifies citizenship as the thing that gives you the right. And so non-citizens remain excluded. The disabled were often unable to vote. People with physical and mental disabilities actually pose two very different challenges to Section 3. Some mentally disabled people were excluded from voting by the Voting Rights Act federally and by provincial acts. The physically disabled were not excluded from voting by law, but many found the rules regarding how one could vote, so on your own, marking an X on the ballot, without anybody at the box with you, getting into the place where the ballot is, and so on, as restrictive and making it impossible for them to vote. The federal government did a study of obstacles to the disabled and the right to vote in the 1980s, and in 1992 and 1993, Parliament passed laws rectifying both of these issues. In 1992, legislation amended the Elections Act to allow for a variety of measures to ensure that the physically disabled could vote. So you can see this from the New Brunswick Elections New Brunswick homepage. So they've got cent-reduced markers, they've got braille controllers for voting with audio, they've got a sip and puff with audio for the quadriplegic, they have paddles with audio, and so on. There are a variety of similar sorts of provisions made in every province and federally. There are rules about what sorts of places can be balloting places. They have to be accessible. And where they are not, then the returning officer has to be able to remove the ballot box to the side of the road, essentially, to let the person who can't get in vote outside. In 1993, the restrictions in the Elections Act regarding the mentally disabled were removed. Canada is, at least as of the early 2000s, I'm not sure whether this has changed much, but in the early 2000s, it was one of only 4 countries that had no restrictions on the right to vote by the mentally disabled. These changes were made by legislation on the part of the federal government and then followed by the provincial governments because of activism on the part of the disabled. But they were not made as a result of any litigation. This is really important. What we find is that democratic rights are often brought to light through the actions of the legislature and the actions of people pushing for changes, not through litigation. It's not always the case, though. The next major group who were excluded from the vote had to get their right to vote through litigation. Prisoners were excluded. It's clear that the intention of the framers was to keep prisoners excluded. But in Manitoba in 1986, and then shortly after in Ontario, groups of prisoners challenged their exclusion from the right to vote in courts. And in Manitoba, they were victorious. But the decision at the lowest level of the court in Manitoba left that change only applicable in Manitoba. So prisoners at Stony Mountain Penitentiary could vote federally and provincially, but prisoners in the rest of the country could not vote. The Ontario litigation that started roughly the same time, in that litigation, prisoners lost. But in 2002, in Sauvé versus Canada, the Supreme Court finally ruled, and they overturned the ban on prisoners voting. And you can see this in Chief Justice McLaughlin's decision and the quotation we've got here. So we have this sort of traditional view of criminals. Criminals are people who have broken society's norms and may therefore be denounced and punished as the government sees fit, even to the point of removing fundamental constitutional rights. If you're reading that closely, that might imply that capital punishment is legal, but she's not actually talking about that, but it certainly presents that as a possibility. But she goes on, yet, the right to punish and to denounce, however important, is constrained. It cannot be used to write entire rights out of the Constitution, and in this case, she means the right to vote. It has to be maintained, and so prisoners are allowed to vote. Yet, we still do not have universal suffrage. The largest group of people excluded from voting in 1982 remain excluded from voting today. I speak here of youth. Youth make up roughly 20% of the Canadian population, 1 in 5 people, and none of them can vote. Now, there are lots of arguments about why children shouldn't vote. All of those arguments are wrong, and I'm happy to explain why in the question period after. But just trust me on this for the moment. If you think children shouldn't vote, you have no leg to stand on. Infants. You're born, you should be able to vote. So, and we can carry this discussion to the end. Well, it's 18 right now. But there's nothing in the Constitution that says it should be 18. It says citizens, and an infant is a citizen. So, well, they can be. If they meet the other qualifications, they can be a citizen. All right. So, this is Section 3. Sections 4 and 5 are different. Here they are. So first, Section 4. No House of Commons and no Legislative Assembly shall continue for longer than 5 years from the date fixed for the return of the writs at a general election of its members. In times of real or apprehended war, invasion, or insurrection, a House of Commons may be continued by Parliament and a Legislative Assembly may be continued by the legislature beyond 5 years if such continuation is not opposed by the votes of more than 1/3 of the members of the House of Commons or the Legislative Assembly, as the case may be. 4 and 5, there shall be a sitting of Parliament and of each legislature at least once every 12 months. These rights are remarkable. They are the only sections of the Charter of Rights that have never been litigated at all. They have, combined, been cited only 4 times in any judicial decision since 1982, and their meanings have never seriously been discussed, even in those decisions. But in some ways, these are incredibly important rights. Section 4 adds teeth to Section 3. Section 3 guarantees the right to vote, but Section 4 ensures that you get to exercise that right to vote with some regularity. And that's important because of the potential for long parliaments. During the English Civil War, the Long Parliament sat intermittently from 1640 to 1660. During the American Revolution in Nova Scotia, the House of Assembly sat with an election between 1770 and 1784. In the 20th century, Canada's longest parliament was between 1911 and 1917, more than 6 years. The expectation, both by tradition and legislation, was that Parliament would sit no more than 5 years, and that's what we've got in the Charter. But the formation of the Union government under Robert Borden forestalled the election for a year. And in fact, they fought the election in 1917 on the grounds that they shouldn't have to fight an election at all, and and it was all Laurier's fault. And Laurier was in some ways a traitor, working with the Germans and the Austrians by making people have to vote in an election. In the UK, there was no election during the Second World War, so between 1935 and 1945. And the exceptions that Borden relied on in Canada's case in the First World War remained. Section 5 guarantees that parliaments and legislatures will sit. Now, one could argue, in fact, legislators in several provinces, including in Alberta, have argued at times that it is unnecessary for the legislature to meet every year. That outside of the budget, there is no new legislation required, and so no sitting of the Assembly is necessary. And the budget itself is only sort of necessary on an annual basis. If either any level of government failed to pass a budget, it wouldn't shut the government systems down. The requirement of the Canadian, let me rephrase that. And it's worth realizing that this is a serious argument by these legislators. Texas, famously, only has one sitting every 2 years of its state legislature. The Canadian government, though, and provincial governments are responsible governments. The Prime Minister or the Premier and the Cabinet rule at the pleasure of the legislature, not at the whim of the people. And so, as this happens most obviously in minority situations, but it can happen in any government, if the members of the Assembly or the House of Commons decide to vote that they have no confidence in the government has to resign. And this requirement of meeting every year is about that. It's not about the functioning of government. It's about making sure that government is accountable to the people for who have responsibility over it. And it's this threat of no parliament is sort of premised on two things. It's premised on a fear of the actions of the monarch traditionally, or certain types of autocrats, to remove the requirement for democracy. It's also a fear of presidential style government, of government run by the executive through executive order without accountability to a legislature. The right itself is actually a restatement of Section 20 of the British North America Act, which required the federal parliament to meet once every 12 months, and Section 5 just expanded it to the provinces as well, but it's there. Now, these rights preserve some very peculiar parts of our democracy. They preserve the right for a citizen to take part in the making of government, the right for citizens to take part regularly, and the right to have their governing done in public, at least to a degree. Each of these rights are important, but there are severe limitations on these rights. So the first question is, how do you solve a problem like Viktor, as in Viktor Orban, or Recep Erdogan, or Donald Trump, who've all been accused of activities that impinge on free elections? Can sections 3 to 5 limit the activities of similarly minded prime ministers or premiers or governments here? The answer to some is that the acts actually allow for a great deal of legislative action to limit democracy without ever infringing on the rights. Prior to 1993, the federal election, prior to the 1993 federal election, the federal government passed the Elections Act that I've already mentioned, removes all the restrictions that prevented mentally disabled from voting. But the same amendments put in clauses that were clearly aimed at trying to hurt the nascent Reform Party bloc Quebecois. The changes put significant threshold requirements on parties. Parties had to run 50 candidates to be officially registered. If they didn't run 50 candidates, they would lose the registration, and in the space between when candidates get registered register and the actual election, the ballots would be composed, and the party name would not appear alongside candidates from those parties of less than 50 if it had less than 50 candidates. The party would also then, if it lost its registration, it would forfeit all of its assets to the government of Canada. And the party could issue tax receipts. Then, at the election itself, every candidate had to put a $1,000 deposit in to run for a federal election, but they would only get it refunded if they achieved 15% of the vote. This could create serious problems for small parties, for regional parties, like the Bloc Québécois and like the Reform Party were at that point, and for parties that are beginning to start to form. So, who solves a problem like Victor? The Communist Party of Canada. The Communist Party of Canada in 1993 is going through an identity crisis brought on by the collapse of the Soviet Union. Its new leader, Miguel Figueroa, who had just replaced Hardy Baines, who had been the leader for more than a decade, tried to bring the party together, but in the 1993 election, they were only managed to have 8 candidates, which meant that they lost the registration, they were supposed to forfeit all of their assets, and so on. And so he challenged the federal act in the Ontario Superior Court, and through a series of appeals, first at the Ontario Superior Court, where he won declaration that the election deposit provision of the Act reached Section 3. At the Ontario Court of Appeal, he got a ruling that the 50 candidate minimum to get your name on the ballot reached Section 3. And so they didn't set a number, and new legislation passed by the Liberal government in the 2000s set that minimum as 12 candidates. And at the Supreme Court of Canada in 2003, he wins little extra than that, but he gets this statement. Justice Yacobucci in his ruling says, the purpose of Section 3 is not to protect the right of each citizen to play an unlimited role in the electoral process, but to protect the right of each citizen to play a meaningful role in the electoral process. And that is a limitation on the Communist Party or other parties, but really it's that meaningful role that is more important, because that meaningful role has meant that small parties with small percentages of the right the vote get to play an active role in hope of building up membership. And we can see that most clearly effective in the Green Party, right? Which 2 decades ago had no MPs or no MLAs anywhere, but slowly built over time and was able to maintain its name on ballots provincially and federally to the point where we have an MP right now, and we might, as at the end of the day, have a provincial government. That's a Green provincial government. We as one province in Canada, not us. So that's the first potential problem with these rights. But there are further rights. And the first one is, who enforces them? Well, yeah, the first one is who enforces them. Section 3 has been interpreted and enforced by courts. But we don't know who can enforce Section 4 and 5. And this is actually a really important question, because Section 3 is an individual right. Miguel could get the changes recognized, or the recognition of parties as included within Section 3, because he could sue as an individual to protect his own right as the leader of the Communist Party of Canada. But in Sections 4 and 5, those are collective rights. It's not clear who could sue to enforce them. We don't know whether a court could do it. And I'll give you an example. Whether a court or anyone else could do it at all. Let's say that the legislature does not sit the Premier announces, I'm not going to have a session in this calendar year at all. See me in 13 months. When, if a court could hear it, when can a court hear it? Can a court hear it then? Or does a court have to wait until the end of the 12 months to hear it? Probably it has to wait. Premiers lie all the time. There's no reason to assume that because a premier says, I'm not going to have a session in the next 12 months, there's not going to be a session in the next 12 months. So if you have to wait until the breach, then it happens. Who gets to be the litigator? Well, the monarch, maybe, but the monarch as the crown is the government, under the government's control, and it's unlikely, there might be crown lawyers here who could challenge me on this, but it's unlikely that a crown is going to take its government to court. The monarch, irrespective of that, has no authority to do that. It's unclear what would happen if the Governor General, Lieutenant Governor tried to sue the Premier or the Prime Minister. But let's say they go to court, and standing is found. So then you wait for trial, you have a first trial, you have an appeal. At some point, you're into your, well through your second year, and at that point, the Premier says, I'm going to call the legislature. They call the legislature, that cause of action is dead. Because there's no reason to keep going. If its purpose was to have the legislature called, the legislature's going to call. So we don't know whether the courts can enforce it or not. But let's say it gets all the way to the Supreme Court. The Supreme Court says, you've got to open the legislature. What forces the Premier to do that? More importantly, if the same thing is on an election, you have to have an election after 5 years, and the Premier says no, and they get a court order somehow that says you have to have an election, why should that Premier hold an election? If a provincial government breaches another charter right, they pass legislation that says public servants can't wear visible signs of their religious faith. And it's challenged in court. It's an individual right, so it's easy to find people who can challenge that. It's challenged in court. The province loses. The province could still refuse to actually follow the court order, but there'd be an election, and this would be clearly part of the election campaign. The government would then, or maybe at some future election, fail. The new government would come in, and they change the law to make it follow the Constitution. But if you're breaching the right to call an election, how do you enforce it through the electoral system? You can't. But there's no provision for the military to step in. There's no provision for the federal government to step in on the provinces and say, you have to have an election, we'll hold it for you. There's no provision that in the inverse, where the provinces can compel the federal government to do it. These might just be aspirations. And so, even with the Communist Party of Canada, maybe we can't solve the problem like Orban or like Aragon. Can we wait a minute? Yeah. All right. Finally, there's another problem, and that's the inherent problem of actually following these rules. The rules promote the refusal to respond to serious crises. We face lots of really serious national and global problems. We have an aging population, and with that, related implications for healthcare costs on the one side, and for revenue generation by a working populace on the other. We have an aging infrastructure, and the investment costs to maintain and improve it that extend well beyond the life of any one legislature, and thus make it unlikely, or make it difficult for legislatures to always sort of vote money to deal with these issues. And perhaps most importantly, we face the threat of climate change. It's global, it's national, it's regional, and it's local in its implications. It's an existential threat to not only our society, but the humans and other living things on the planet. The changes it will wreak globally will lead to the death of many humans and the extinction of many other species. And these in turn will lead to major migrations of people, and that will in turn create fundamental stresses on the spaces less directly affected negatively by the effects of climate change. The requisite changes of burning carbon fuels will require serious changes in Canada or in Alberta. And yet we've seen in the last several election cycles, nationally and provincially, not just in Alberta, but across the country, that with an election every 4 years, any serious attempt at addressing climate change is impossible. What, for example, will be the new government's first piece of legislation? To repeal the carbon tax. Now, is the carbon tax the best way of resolving the carbon addiction that we have? Perhaps not. But the new government has no actual plan for addressing climate change either. It just has a plan to remove the carbon tax and to defund provincial programs aimed at diversifying Alberta's energy sources. No government has the time to deal with the economic effects and the changing demands brought on by climate change and the need to get off of carbon fuels. And every opposition has an impulse when a government tries to act to argue against any actions that have been taken. Whether it's here, or in Alberta, or in Ontario, or New Brunswick, we've seen this in each of these jurisdictions. We'll see it continue. So, what are we left with? We can celebrate these three clauses, as being a constitutionalization of our democratic practices. But we need to recognize that the rights have not, and still have not been universally applied, that their enforcement seems to rely heavily on governments deciding that they want to live up to the rights without any enforcement mechanism independent of that. And they create a system, because of the requirements of time, that make it very difficult for democratic governments to actually respond to the crises we face. So, I'm open to questions. I've proposed some.
So much question as a comment. So I've read about, in some jurisdictions, I'm not sure in Canada, perhaps not in Canada, there are now ministries for the future to deal with that last issue about longer term thinking. Would that be, could that operate in Canada?
Sure.
And I guess the other way of thinking about this is this notion of citizenship.
Yeah.
So can the unborn be included within our notion of democracy?
So I think the answer to both is yes, and the answer to both is it won't matter necessarily. So let's take the unborn first, right? It doesn't matter what the issue is. We are often told, why don't we think about the children, right? If you look at any discussion of debt, you're told part of that discussion, if a party is against the debt, all parties are actually against the debt. So if a party is fighting the debt a priority, it will tell you how much debt your children owe, or how much debt your children's children will owe individually 100 years down the line if the debt is not resolved at the moment, the deficit is not resolved at the moment, right? So yes, we can rely on them rhetorically. It would be difficult to give them votes, but we can rely on them rhetorically. But in doing so, we are, we open, the rhetoric already exists, and the rhetoric can go both ways. The one proposal for doing it with votes is to give extra votes to people who are parents, or who are pregnant, or who could become pregnant, as a way of recognizing this, a sort of John Stuart Mill type version of democracy, where you give certain categories of people more democratic power because of their particular role. But there's no reason to assume that parents will make the right choices for their kids. Right? I bought my kids a whole lot of Easter candy for like Sunday. Clearly, I can't make the right choices for my kids. And I'm not universalizing well, I am universalizing my experience, but other parents might be better than me, but we still can't count on that, right? So I think it would be very difficult to operationalize. A future ministry, a ministry for the future, is fine. But it works in one of two ways, right? Either it's passing legislation with that goal of a future-minded thing, but a new government can come in and overturn that legislation because that's the basis of our system, right? No government is bound by the legislation of a previous government. The other way of doing it is to have all the parties agree that there is this thing, this ministry, that it will be supra-party, that will deal with that, and so it can persist regardless of who wins the election. And in our current structure, that's not going to happen, right? And we can see this in, say, either the American case or the Canadian case. We use the American case, so it's less inflammatory. The model of Obamacare that was approved, or that was created in Obama's first term, was a Republican model, right? It was, Democrats go for years, this is what we want, they want to follow a Canadian model or something, or a British model, something like that, and the Republicans say, no, 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 that's bad. Here, we'll create this model that is still essentially a private healthcare model, but has certain requirements, and the government can help those who can't afford private insurance in limited ways. And the Republicans are opposed to it, right? It's a model they created, they're opposed to it, because politically, they are going to be the opposition, right? Climate taxes work the same way, right? Climate taxes are a conservative response to the need to control, or a market-based conservative response to the need to control climate change, and their greatest opponents are conservative parties that celebrate the market. So, so it just doesn't seem to me as likely with the oppositional structure of politics that we have, that you can get a ministry that's going to be supra-party, and that the parties are going to sign on to. You had a question quite a while ago, and then I'll move to here.
Referring back to the 367 days of a legislature instead of 366 to take a leap period, wouldn't the government at that point just simply cease to exist because it's no longer following the law? So that government per se, by definition, is no longer government.
So, what takes its place?
Well, that's why I refer to the monarchy, because the government is appointed, right, by the monarchy at that point.
Yeah. The idea that the monarchy could step in and do something. So we can use the example of the potential loss of a vote of confidence that Prime Minister Harper faced in 2009. Yeah. The Governor General, he didn't actually lose the vote, right? But the Governor General, he has his meeting with the Governor General, and there's this sense that the Governor General has options. She can refuse his request for prorogation. If there is a vote of non-confidence that day in the Commons and he loses, she could require that he resign. But the argument made by the Conservatives and by their supporters and by people who weren't their supporters but had a particular view of the way democracy works in Canada was to say that that would not be legitimate. Right? That the Governor General, because she's this appointed person, really doesn't have the authority to call into question the actions of the elected representatives. And so if the Prime Minister says I want a prorogation, the Prime Minister says I want an election, then the Governor General doesn't get to say no. And we can see recently where Governor Generals haven't done that. Right? We can see the Australian case from the mid-70s, where the Governor General essentially had a coup against the Labour government, launched a coup against the Labour government, and now, Australia is still a monarch, representative monarchy like ourselves, but it's the Republican movement in Australia is linked very closely to the fact that the Governor General did this. The Governor General's actions have caused continued disrepute for certain parts of the way the government works. So I just see it was unlikely, even if the government is in disrepute, I see it's unlikely for the Governor General to do this. On top of which, the Governor General and Lieutenant Governors, you know, like, they have a staff of 5. These These are not people, and the staff of 5 are there to help them get to places and make their speeches on time. This is not a staff that can function as a sort of force against.
But we could force it.
How?
Any law that is passed by a legislature which is illegal is not a legal law.
Yes, and lots of people make that claim about tax laws all the time, and they go to court and they lose,
Yeah.
right? And I think you were stuck with the same situation, right? It would be plausible, that there would be enough of an uproar against it, right? But the likelihood is actually inverse, right? That the parliament, the government choosing not to have elections would do it in a way that sells the idea that elections are disruptive. We use my last example. We need to fight climate change. If we have an election, we will. This is over, right? We're going to have to, it'll start from beginning all over again, and our children will be doomed. The only way to actually deal with this is to not hold an election, and they will convince some significant portion of the population, not necessarily a majority, because they don't need a majority. They'll convince some significant portion of the population that they're right, that an election is dangerous, and they'll persist without an election. And they'll have some, not universal, but they'll have some legitimacy.
Couldn't there be court challenges to individual ministerial directives, individual orders in council, individual instances of royal assent, whittling down the government's power to nothing?
Yeah, but all of those, any court action against the government requires the government to voluntarily live up to the ruling against it. There's no force that can compel. If I lose a civil action, right? Somebody sues me and I lose, the police can eventually come in and force me to give up my stuff, right? It's difficult, but it can be done, right? Certainly if there's a criminal, if I break the criminal law and I'm convicted, you know, the police can catch me and put me in prison, right? There is no equivalent force that can compel the state to follow a law, a court order that goes against its wishes.
That's not entirely true because under the Federal Courts Act, there is a provision for contempt against Canada.
Okay, but how is it enforced?
Well, that of course is the question, but normally, in the circumstance, once you get a contempt order from the federal court, you can require the RCMP to enforce it.
So the RCMP take their orders from the Solicitor General ultimately, and the Solicitor General says, no, don't enforce that court order. What do the police officers do? First police officer says, I'm going to enforce that court order. The Solicitor General says, no, that officer has been fired, and the rest of you should arrest that officer for breaching whatever, right? I agree, there are these little provisions, but they all count on people in government, in the end, respecting the rule of law, and there's nothing that compels the government to respect the rule of law when it doesn't have to face re-election.
True, but you're talking then about the whole system falling apart.
Yeah.
So basically the whole Constitution Act is gone.
Yes. Yeah, I agree that. That's exactly what I'm saying. But what I mean by that, it's not going to happen with virtually any other right. Because in the end, virtually every other right can be enforced at the ballot box as long as there's an election. But if you give up, if the right you're breaching is not going to have elections, then the people through the ballot box can't change it. And, you know, we don't have, neither do we have a tradition, nor do we have the capacity for the people to compel the government to act through violence, which would be the only alternative to revolution. That's not going to happen, except in a really extreme case.
So as a historian, how would you assess the reason why, because this is an interesting incongruity, but why would you say there hasn't been a civil war since the English Civil War? Like, what's so successful in the English common law tradition that it hasn't actually come to blows?
Yeah.
The simplest answer is so let's say a government chooses not to have an election, right? We know what this is like. We know what this is like from the experience of Germany in the 1930s and 40s, first half. Right? There were a lot of people who did not support the government. But they also saw the government acting in ways that meant that if they were to resist actively, they would be imprisoned, they could be tortured, they could be killed. And so a lot of them chose not to resist actively. It's a lot easier to grin and bear it and hope that eventually things will change, but be able to spend the night with your family than to say, this is such an important thing, I'm going to risk my life to resist the government's action. Very few people are going to do that. It needs to be extreme. And we see this time and again in all sorts of places where governments act with great violence. Right? It takes a lot to get people to resist. And even then, those who resist are small in number.
This will be our last question.
In the early 1990s, Ralph Klein was trying to introduce his third way with healthcare,
Mm-hmm.
and there was a massive demonstration at Parliament, the legislative buildings here. And that's a case, maybe, where public pressure en masse influenced him to change, to back down on that.
No, exactly. And I think we can see that, like Klein actually posed a good example, right? For both, in the sort of the small act that he first tried with privatizing the laundry workers, and then the larger in the hospitals, and then the larger act of introducing a whole lot of private options or systems more private systems within the healthcare system. And in both cases, we saw resistance. So in the laundry workers case, the laundry workers in Calgary go on strike, and then that strike spreads to a lot of other workers. Doesn't last very long, but it's enough for the government to flinch for 12 months, and then to negotiate slowly a privatization. In the case of Medicare, the protest is much larger, and again, the government flinches. But in both cases, the government flinched because it needed to run for re-election. If Klein didn't think he was ever going to have to face the electorate again, say, I am just going to lead until I die. I'm just going to rule until I die. Then it doesn't matter how many hundreds of thousands of people show up in the legislature grounds unless you think they're going to attack you physically. If they're not going to physically take over, if they're just going to arrive on the LRT with their signs and sing their songs and then leave at 2 in the afternoon, then you don't have to pay attention if you don't expect there to be an election. If you expect there to be an election, you have to pay attention.